The Supreme Court is hard at work on the Trump disqualification from Colorado case, and it's clear that they are going to handle this very, very quickly. They took the case quickly, and they are working on it. And how do we know that? Because we keep getting these notifications about things that they are looking for. So they first asked for the record, not a surprise, but the record from the Colorado Supreme Court, which means the written transcripts from what they ruled and their entire everything that they reviewed. They also asked for the record from the Colorado District Court today. And so they are just methodically going through it all. You would think that the record from the Colorado or the Denver District Court actually is where it was heard, which is the lower trial court where they had the trial. You would think that they would also have that the Supreme Court, the Colorado Supreme Court record would include anything that is in the lower court record. But I'm not really sure why they needed to go down to the Denver District Court to get part of the record. But let's just talk a little bit about what's going on here. The Supreme Court, just for people who don't practice Supreme Court, in the Supreme Court, which I don't actually, but I'm familiar with what they do. Like any appellate court, they only look at questions of law. They don't look at questions of fact. That's for the lower court to decide. What they do is they accept the facts from that are developed in the lower court, because the lower court takes testimony and sees evidence and rules on relevance and admissibility. And when you have testimony, if you're the finder of fact, if you're a jury or a judge, you can look at someone in the eye and tell if they're being evasive or credible, and so you make determinations, right, based on how they testify, not just the words they say. And so things like credibility determinations are always left up to the finder of fact. And like I said, the judge below the parties want to dump in as much evidence as they think helps their case, but judges are the referees who have to say, no, this is not admissible, or this is not relevant, or it's relevant, but it's too prejudicial, that sort of thing. So the judges build a record of relevant, admissible facts, and then there are findings of fact, and that's what the Denver District Court did here after, I think it was a 5-day trial with witnesses and testimony on whether or not Trump should be disqualified based on the 14th Amendment for engaging in an insurrection, because we know by now that there is this 14th Amendment disqualification clause in the Constitution that was created or passed after the Civil War in order for to build the country back and not have traitors be allowed to run for office, essentially. So it was unusual for the court to agree to hear this case without specifying the legal issues that they intended to decide. That's something that George Conway, who's a Republican commentator, wrote in The Atlantic, that normally the Supreme Court will specify which legal arguments they're going to hear because as I was saying, it's not about the facts, it's about the law and what they determine. There's lots of things that they could choose to discuss on the law, right? Is there jurisdiction? Is in any general case, right? I'm talking generally, not necessarily this specific case, but there's lots of different legal theories or legal issues that a court could consider that some have. Like sometimes it's about the jury charge that was given, or sometimes it's about a piece of evidence that was admissible, or it's about ineffective assistance of counsel, or whether there's venue or jurisdiction. There's so many legal arguments that lawyers will appeal on, and the appellate court sometimes hear all the legal arguments, or sometimes they just say, you know what, I only want to hear this issue. So let's just decide and brief this particular issue. And then the parties are aware of what it is that they are going to have to brief and what the appellate courts are thinking. Because if you're going to reverse a case, you only need one ground to reverse a case. It doesn't have to be everything. And so what Conway was saying in The Atlantic was that it's unusual for the Supreme Court in particular to not specify, because they're so busy, they get so many requests and so many cases, that they typically will let the parties know which particular legal issue they want to decide. And here, both the Colorado Republican Party and Trump both petitioned the Supreme Court to take this case when Trump was disqualified from the ballot in Colorado. But so far they've only agreed to hear Trump's petition and didn't rule yet on the Colorado Republican Party. But what's odd, like I said, according to George Conway, is that they would take up the entire case and all the issues presented to them, not specify what it is. And, look, there's lots of issues in this case about what they might want to hear, right? Did the Colorado Supreme Court commit error when they excluded him from the ballot? That's the question that they said was the question they want to hear, right? That's not really a question of law, though. That's more of a question of fact. So it's interesting why they didn't specify what they're looking at. Because, for example, they could say, is the president of the United States an officer? Because this disqualification clause of the 14th Amendment specifically calls out numerous positions like the vice president, secretary of state, other officers, but it doesn't specify the president. And the district court actually ruled on that and said, we find that Trump engaged in an insurrection, but the district court in Colorado said he's not an officer. Now, that was overruled by the appellate courts in Colorado. And so that could be the question that the Supreme Court is looking at. Do they agree with the district court who said he's not an officer? Or not. I mean, most legal scholars think that if you look at the legislative history behind the 14th Amendment disqualification clause, that you would see that it clearly does cover the president. And that was specified in the legislative history, that they thought the word officer was general enough that it could be anybody. They didn't need to write it in there. But let's see what the Supreme Court says. Another legal question they could want to address is, did Trump take an oath to support the Constitution? Because that's another element of the disqualification. It's an officer who took an oath to support the Constitution. Trump has argued that he didn't, which I think is kind of outrageous. I don't understand, A, how he can say that, and B, how we can accept that as the American people. Of course he did. We all saw him at the inauguration put his hand up and swear to support the Constitution of the United States of America. So how could he even say that? He said, I took the presidential oath, not the oath to support the Constitution. It's the same thing. So that's an outrageous argument. But again, they could rule on that. Another one they could rule on is the 14th Amendment Section 3, which is the disqualification clause, self-executing, or is it a political question that requires an act of Congress? So in other words, that's the only, what that means is, does Congress have to pass a law defining these terms and saying what it means to disqualify someone to engage in an insurrection? Or is it just something that the states can interpret? And the states every state has their own election law, right? Like the Constitution says the states get to decide the time, place, and manner of federal elections. And so every single state has a separate election law. That's why some have caucuses and some have primaries and some, everybody does it differently. Some require petitions to get on ballots for a primary, certain numbers, and others require fundraising. I mean, it's everything is totally different. Some allow mail-in ballots, others allow. That's why they all have different dates, right? That's why there's a Super Tuesday for the primary and other dates. Every state is different. And so is this something that the states can also interpret differently, or is this something that Congress has to pass a law? Or is it and another question they could ask is clearly this is a qualification section, right? Are you qualified to run for president? Is it more like age, right? You have to be 35 to be president, or you have to live in the United States for 14 consecutive years, and you have to be a natural born citizen, right? That's a qualification. And if you were 18 years old, born in France, you couldn't run for president, right? And every state would keep you off the ballot. But so is being an insurrectionist or having engaged in an insurrection or provided aid or comfort thereto, which is the language, is that more like age, or is it something else, right? Is it something entirely different? So there are lots of things that the Supreme Court could have specified that they were going to decide this on. So again, did he engage in an insurrection? What does that mean? Is that a factual question? There's just so many things that you get the gist of what I'm saying of what they could have done and didn't do. But they are asking for the record. They are looking at the record. They are busy at work here on this case. We should expect to hear them rule quickly, and we will know whether or not Donald Trump will be on the ballot in Colorado. Another question, by the way, is does it apply to primaries or does it apply to the general election? Trump has also argued alternatively that you can't keep him off the ballot. You might be able to keep him from being president, but you can't keep him from running for president because the Constitution says that you can't hold office if you've engaged in an insurrection. It doesn't say anything about running for office. Again, strange argument, but this is what he's making. So stay tuned, stay informed, and stay aware, and we'll see what the Supreme Court ends up doing in this case, but we know they're working on it. We know they're working quickly on it. And hopefully the DC Circuit will rule on presidential immunity in the Jack Smith case soon, and the Supreme Court will treat that case with the same urgency and the same speed, because that case benefits the American people, just like this case that we're talking about, keeping him off the ballot in certain states, benefits Trump. So I hope they recognize the importance of treating all of these cases quickly. I'm Karen Friedman Agnifilo with Legal AF. Join me every Wednesday and Saturday with my co-hosts Michael Popak and Ben Meiselas.
Hey, Meidas Mighty. Love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.